Get out. Yeah, you.
All right, lawyer. Lawyer. Lawyer.
Yes, lawyer, lawyer, lawyer. 3 of the best words you could possibly say, because let's face it, everybody loves their lawyer. They hate all the other lawyers in the world, but they love theirs. So thank you, Crime Talk aficionados. Thank you for joining us here tonight. We appreciate you taking the time to join us. We have, I hope it's going to be a good show for you. A couple things we want to talk about. A little stuff in Kohberger, the Brian Kohberger case there in Idaho. More discovery requests. It just drives me nuts that we cannot see what is attached in these documents. We'll talk about that. All right. We have the prosecutor in the Alec Baldwin matter that filed some pleadings in the Hannah Gutierrez case and basically said the judge misunderstood what took place in the Alec Baldwin case. And then, frankly, that case shouldn't even have been dismissed, but the judge got it wrong. So we can talk about that as well. Obviously, we talked today in our show about the Justin Timberlake matter. I think he will ultimately plead guilty to a lesser offense, something along those lines of like a driving while ability impaired. Drunk driving, I think, is one of the most preventable crimes that one can commit these days. Everybody knows you shouldn't do it. So many people still do it. Even in the age of ride shares and friends and cell phones, it still happens, even to famous people. But let's not beat them up too hard. Let's be realistic. The first one can happen to anyone. We've all known somebody that's had a DUI. It can happen. It's the second, third, and fourth that, needs to cause you great alarm, because obviously somebody has a problem, and it's not a driving problem. It's a drinking problem, right? We can briefly discuss that as well. And of course, I'd also like to discuss the Sarah Boone matter a little more in depth than we did today. Now, we talked about it. Sarah Boone, let's just start with Sarah Boone. All right. She's on trial down in Florida. She has a boyfriend. Somehow, the two of them decide to play a game of hide and seek, or something along those lines. I'm not really sure how the game of hide and seek really works when you help the person hide, like, i.e., oh, I know, I'm going to be sneaky. Put me in this suitcase and zip me up. And then Sarah Boone's zips her boyfriend up into the suitcase, and then ultimately he dies. Well, needless to say, Sarah Boone, the last person with him, the person who admitted zipping him up and putting her boyfriend, old Jorge Torres, into the suitcase, is ultimately charged with murder. Now, Sarah Boone, what's the word I'm looking for? She must be a very difficult person to deal with, unless, of course, you are asked by her to put yourself in a suitcase and zip yourself up and ultimately die. Okay, that whole thing is weird in and of itself. Weird, right? So then you got Sarah Boone. She goes through 8 attorneys, and she doesn't get number 9. Judge says, you, ma'am, Sarah Boone, have forfeited your right to have an attorney, because this case goes back to 2020, and we're still trying to get it tried here in 2024 because she goes through attorneys. She doesn't like them. She thinks they're all incompetent, and she thinks that anybody can do this. And as I mentioned in the show today, not to rehash all that, but Sarah Boone is figuring out that it takes a little more time and effort to be an attorney than to just sit there and criticize one all day long. And the judge is saying, yeah, sorry, you forfeited that right to have an attorney. Now you may say, well, hey, isn't that violating Sarah Boone's right to have an attorney to represent her? I mean, let's face it, everybody who's in custody has a right to an appointed attorney. If they're out of custody, if they qualify, they should have a right to an attorney at a state expense if they qualify. It's quite common. Heck, you go through a lot of courts these days. It seems like there's fewer and fewer private cases taking place just because, well, there's lots of things going on. I think the economy is slowing down. People don't have that extra cash to spend on it. And frankly, you're just seeing more and more serious cases because none of the smaller cases are being prosecuted like they used to be. I knew guys that used to make livings on DUI cases or just doing misdemeanor cases. But now they give such sweetheart deals, you don't even need an attorney in the sense that they don't even file the cases. It's ridiculous. Or you can plead guilty and then it gets sealed right away. So, like I said, so Sarah Boone is figuring out that this is a little more difficult. But is it really violating her rights? Is it violating her right to have an attorney? Well, if she's convicted, I guarantee you she will argue that the court not giving her attorney number 9 is a violation of a constitutional right to an attorney in a criminal case, particularly where the case is, could result in her going to prison. And you may say, well, that's just right, unfair. And I didn't represent I represented a case years ago. I didn't do the lower level trial court stuff. But this particular individual had went to trial, lost, got sentenced to a lengthy sentence, went through the appeals. One of the issues was, hey, I didn't forfeit my right to an attorney. I should be allowed to have one. So ultimately, I got, I wouldn't say bamboozled, but I couldn't say no. And I wound up doing this federal habeas case. All right. I was more of a consultant on the lower level stuff. But, federal habeas is after you've done all of your appeals, post-conviction relief. You basically have had to exhaust all of your remedies in state court before you can go to the federal habeas court. And you got very limited times filing various habeas petitions. So anyway, we did a bunch of research about forfeit of counsel. And basically, yes, you're going to get 1 or 2 continuances, but maybe even if you hire private counsel, and in the particular case that I was referring to, the attorney showed up and said, hey, judge, I just got retained. It's a complex case. The client's looking to spending the rest of his life in prison. I need a continuance, is what the trial counsel said. The judge said, denied. This takes place every time. It's taken place through, I think, 4 attorneys. So you're number 5. You come in here, you ask for a continuance. As soon as we get to trial, the defendant fires the attorney, what have you. So he said, no. Attorney says, hey, listen, judge, I get it. I just don't want the guy to go to trial without an attorney. Even me unprepared is better than him trying to do it himself. Judge said, let me think about that. Yeah, no, we're going to trial today. We're going to trial now. Have a seat, bring in the jury. Let's begin voir dire. Like I said, the client gets convicted. I wasn't the trial level attorney. So like I said, it was habeas stuff. Habeas. So it just shows you the spectrum of my knowledge. He can go try a case. He's done appeals that have gone to the United States Supreme Court. And then he can do habeas post-conviction. And yes, I've even done some post-conviction work, but I despise post-conviction work unless you are truly claiming a case of actual innocence. All right. Like, hey, I'm the wrong guy. Go test the DNA. That evidence wasn't available. But he didn't explain that to me. Some total lie that somebody writes in prison because they think about, man, I'd be out right now if I had followed my attorney's advice, but I didn't follow my attorney's advice. And so I went to trial and I lost and I got a lot more time. And now I'm regretting that decision. So the only way I can do that is say that my attorney did something wrong. And I hate that. I hate it with a passion because attorneys, we document things. We document things. You're proceeding against my advice. Take the deal. I believe you'll lose a trial. Anyway, so I hate those. Anyway, so the whole issue goes up, and we're thinking, man, we have a shot. I'm like, there's some cases out there, but yeah, the federal judge said no. The judge said, yeah, this guy had plenty of opportunities for attorneys. It's clear and obvious that they are playing games. They're trying to intentionally delay and manipulate the court system, and therefore proceeding to trial without an attorney, they forfeited that right. And so, like I said, I have a little bit of a perspective on that. I've done quite a bit of research on that. Yes, you do have a right to counsel, but not an indefinite right. You don't have an unlimited right to the number of attorneys that you get. And frankly, I'm surprised that the court in the Boone case gave up on request for attorney number 9. But I love and I hope that the judge continues to stand strong and not give Sarah Boone a new attorney. Like I said, she has given up that right. And it's just, like I said, it's one of my pet peeves. I will go to the ends of the earth for a client. But when they are playing games and you wind up, I mean, one of the biggest, when your spidey senses start tingling, ooh, something's wrong, is when somebody comes in and says, I want to get rid of my attorney. And then you have to ask yourself, really, why do you want to get rid of your current attorney? Well, he's just not telling me what I want to hear. Well, then it sounds like he's doing your job. Well, he doesn't want to go to trial. Well, no, did he say he doesn't want to go to trial, or he's recommending that you not go to trial? Because remember, ladies and gentlemen, when attorneys tell somebody you should probably take the deal or seriously consider the deal, they're doing that in your best interest because they make more money if they go to trial. A lot more money. So if they're telling you to take the deal, they're telling you because that's in your best interest, which is who their duty of loyalty is to. The client. So, like I said, going back to Miss Boone here, she had 8 attorneys, couldn't get along with a single one. And we're talking really good attorneys. These were well respected. Some of the people were referred to as client whisperers. They got the difficult clients to handle the difficult cases. And so Miss Boone pushed her thing. For whatever reason, she doesn't want to go to trial, right? She says she's innocent. And it's simple, that there wasn't any intent and the death was an accident. So all Miss Boone has to do, right? Say, prosecution, bring on your witnesses. When it's my turn, I'll get up and tell my side of the story, and we'll let the jury decide. It's always funny. You got the clients that don't want to plead guilty, like a Sarah Boone, but they don't want to go to trial either. Apparently, Ms. Boone has come to the realization that she is going to spend some time in custody. She's already been in custody for almost 4 years now. And they're really no closer than they were before, other than, maybe we'll have a trial date here soon. Maybe we'll have a trial date. But, we'll just have to see how this plays out. But Ms. Boone, it brings me great pleasure. And don't get me wrong. Okay. I get it. There's lots of people that are going to say that one story. Well, there was that one guy, he was pro se and he beat the case. I get it. It happens. And there are prosecutors out there that their goal in life is to never lose a case against a pro se defendant. But oftentimes, it's like a neighbor dispute. It's a traffic court situation. Haven't seen a whole lot of pro se defendants walk on homicide cases like Miss Boone. Just not that common. And every now and then you get the guy, you see him in court. He shows up. He's got his red rope. He's ready to go. And he's got all his stuff. He's, got his ankles and shackled, and he's come out with a belly chain, and he's holding this stuff, and the sheriff's trying to help him get it up to the podium, and he wants to then pull out a piece of paper, and he's pulling it out slowly, and he's like, "Judge, I want to make a motion to dismiss the case for a lack of evidence." And the judge is like, "Well, sir, did you file that through the appropriate electronic filing system?" "Well, no, I did not." "Okay." And then the person says, "Well, I'll file that. I'll have my investigator do that." And then the investigator, who will maybe be there in the courtroom, is like, "Nah, that's beyond my scope." Right? Sarah Boone wants advisory counsel. Early in my career, I took a couple of appointments, getting your practice going as advisory counsel. And I swore I would never do it again. And then I did it again. And then I swore I'd never do it again. Okay. When you're advisory counsel, you're supposed to be the attorney, and the defendant is supposed to use you as a resource, like ask you questions. Yes, there, wise attorney one. How is it that I lay the appropriate foundation for business records? And you say, "Well, I've got a book on that. I can photocopy those relevant pages and give that to you." And maybe you can give them an example. But usually what it turns into is, "Hey there, wise attorney. I don't have access to a computer. Could your office type this up for me?" "Sorry, no." And then you feel sorry for the person. Next thing you know, you're typing it up. Or you're doing research. And same thing for investigators. Miss Boone has an investigator on this case. And the investigator company is Jailbreak Investigations. Can you believe that? Jailbreak Investigations. Very interesting, isn't that? Anyway, Jailbreak. So Miss Boone has an investigator. She's also been given funds to hire a psychologist, but she says, "But I don't know who to hire. I don't know what to do. I don't know what paperwork to file." That's why you pay the attorney to do it. Or in this case, you sit down, shut up, and let your court-appointed attorney take care of it. That's what you need to do. But she won't, because she knows better than everybody else. So the bottom line is, but she still hasn't seen her discovery. I'm not sure. Well, she doesn't have a copy of her discovery. I'm sure after 4 years and 8 attorneys, she has seen the discovery, not once, not twice, but my guessing is at least 8 times. So everyone out there, like I said, everybody can be a lawyer. I get it. I get it. You Google something, everybody's a lawyer. I know. It's like I Google stuff too, and I'm a doctor too. But when a rubber comes to the road, I'm not going to walk into a hospital and say, "Here are my credentials. Dr. Rice reporting for surgery." I wouldn't know where to begin. I wouldn't even know what floor to go to. What scalpel do I use? I don't know. So anyway, Sarah Boone, do it yourself and save, as we used to say when I worked at a full serve gas station that did mechanics work back in high school. Everyone would be like, "I'm not going to pay a mechanic to do that. No, I'm going to do it myself and save a few bucks." And then, of course, they would have to pay the mechanic shop to go tow the car in, repair it, undo what the, unskilled shade tree mechanic had done, and then put it all back together again at great expense, because, how much money did they save? So Sarah Boone, hey, after all, it's a simple case. You just have to be able to explain why you thought it would be so cute to put your boyfriend in a suitcase and zip him up and then forget about him. Oops a daisy. So yeah, I don't want to be a lawyer anymore, is what she says. I don't want to be a lawyer anymore. That's what she says. Wow. All right. Next on the docket, let me take you here to, let's go over to Idaho. All right. The Brian Kohberger case. The case that also seems like it's dragging on, and there are lulls in any case out there. And now we're in kind of a lull between, we're probably not going to have a trial until next year. Well, we know that we're not going to have a trial until next year. And there's a bunch of discovery issues still going on. We got a hearings coming up in a couple of weeks as it relates to, expert testimony, the hearing as it relates to the change of venue, but yet filed the 5th, which was yesterday, was the defendant's 16th supplemental request for discovery. All right. And so really, obviously, the prosecution in any criminal case has an ongoing obligation to disclose all new discovery in the case. Inculpatory, bad for the defendant. Exculpatory, good for the defendant. And they needed to turn it all over. If you don't turn it all over, you play games. And what happens when you play silly games? You get silly prizes. Just ask the prosecutors in the Alec Baldwin case. They got a little too cute for themselves. And frankly, I don't think that evidence would have been of any relevance whatsoever, but we'll never know because they tried to hide it, or at least it appeared as though they tried to hide it. So, like I said, Brian Kohberger and his 3 attorneys, remember, he's got 3 attorneys working on the case, and they filed their 16th supplemental request for discovery. And it says, please take notice, the undersigned, pursuant to Rule 16, that's discovery rules, of the Idaho Criminal Rules, the 4th, 5th, 6th, 8th, and 14th Amendment to the Constitution of the United States, and Article 1, Section 1, 2, 13, and 17 of the Constitution of the State of Idaho, requests discovery and inspection of all materials discoverable by the defendant pursuant to the Idaho Criminal Rules 16B 1 through 8 and the aforementioned constitutional provisions, including but not limited to the following information, evidence, and material outlined in Exhibit O. So you're thinking, wow, this is getting good. This is getting good. Exhibit O. Wow, I wonder what's all the other exhibits. Well, there is no, and then you get there to the attachment page. Under seal with the court, Exhibit O, attached to defendant's 16th supplemental request for discovery. It's one of my pet peeves, ladies and gentlemen. This is, it's just ridiculous. Brian Kohberger is accused of quadruple homicide. He is not accused of some sort of state secrets that are going to get out in like some sort of espionage case. If the defense is requesting in Defense Exhibit O, and I have no idea what it is, they're asking for more information as it relates to cell phone tower data. It's something that they think that they're entitled to, that the government has, and they haven't turned it over yet. Well, why shouldn't we know that? And somebody, well, we got to give him a fair trial. Who says you can't give him a fair trial? Look at all the trials where there's been lots of publicity, lots of discovery presented out there, and the people still get a fair trial. It happens all the time. Lori Vallow, Chad Daybell, we know it works there. I mean, hell, most of that discovery was produced and they was put on, Netflix series. But we still know that there's some people out there that will live under a rock, not watch any news, not keep up on any current events, not become a CrimeTalk aficionado, and be up to speed on all of the latest developments in the latest cases that are taking place. No. So we know we're going to be able to find those 12 people. As I had a law professor say, a jury made up of 12 people, good and true, otherwise unemployable. I always thought that was funny, but that's usually who you get. Every now and then, you get the hardworking person that's like, I can't be here. And you're like, no, we're keeping you. We're keeping you. I'm going to keep my eye on you. That's right. We're keeping you. So It frustrates me to no end that we don't get to know what's in the Exhibit O attached to the defendant's 16th supplemental request for discovery as it relates to Brian Kohberger. Now, let me give you just some general sense of my thoughts on the Brian Kohberger case. Obviously, this case has been going on for quite a while. All right. It looks as though, let me just confirm this so we get our dates correct, because we don't want to put any bad information out there. But the affidavit for the arrest warrant, December 29th, 2022. So let's just say, for easy scorekeeping purposes, January of 2023. Here we are now in August of 2024. I get it. It's a death penalty case. You get super hyper due process because the government is going to potentially impose the ultimate sentence, which probably will never be ultimately imposed. But we go through this, I don't know, legal fiction that somehow this case is much more complicated than if it wasn't a death penalty case. And as we saw, for example, in the Chad Daybell case, a death penalty case, there wasn't much of a mitigation case at all. I mean, what do you say? I mean, the guy, he's accused of killing his wife's kids and killing his wife to be with the new wife to kill the kids so they could be together, right? They presented nothing. I mean, and sometimes that's all you got. And so just think about it. If this wasn't a death penalty case, would this case really have been taken? I mean, we've had the same attorneys since the beginning, right? I mean, don't get me wrong. I think it's fair for a good homicide case to take about a year from start to finish. But we're already here at almost going on almost 2 years. Almost 2 years. January would be 2 years on the Brian Kohberger case. And you know what? I mean, why? I guess why? Why does it take this long? Now, I know the attorneys on the case, they're busy. They have other matters, other court appearances, but my guess is this is pretty much taking over the case. I've only done one case where they were considering going death. And yes, it was very time consuming, but most of it was mitigation because you had to make your pitch for them not to go death. And we were successful and they didn't go death. But the case itself wasn't that complicated. It was just a good old fashioned, double homicide, sexual assault, murder, attempted murder. Factually, it wasn't that complex. We just had to explain away the little DNA stuff. You want to talk about some brainstorming sessions when you have to try to explain why your client's DNA is in the deceased woman's anus, right? You got to get creative. How did that happen? How did that just happen to get there? It happens. Let's see here. Catherine Liu, super chat. Thanks for the super chat. We don't ask for super chats, but as you can see, there's lots of comments going by, but that one caught my eye because super chats get put into a nice different color. So Catherine Liu, thanks for the super chat. Can the Brian Kohberger defense continue to request more and more discovery just to delay the trial? How do they know what to ask for? Great question, Catherine. What happens is the defense will get the discovery, all the police paperwork, any notes, memorandum, reports from experts, everyone from the first cop on the scene, then you'll get their body cam video, you'll get their statements, any supplemental reports, follow-up investigation, anything like that needs to be done. Then they consult experts. And then, for example, we know in the Kohberger case, they're like, hey, judge, a couple of times they said, we believe we're entitled to the information as it relates to the genetic genealogy, which was used ultimately to create the profile to get Brian Kohberger's DNA. So at that point, right, they can say, we're entitled to that. We know it took place. We want to see it. Now, can you ask for stuff that's not in the care, custody, and control of the district attorneys? No. But what is care, custody, and control for the district attorney? That's anybody that basically reports to the district attorney. So they'll oftentimes, the district attorney will say, well, Judge, this was a joint task force case, or the FBI was involved, like in the Kohberger matter. And they'll say, yeah, they don't report to us, Judge. So I don't have that information. It's not, I can't ask them. And the judge in the Kohberger case said, no, they worked on it with you. You need to produce whatever reports that they have. That's what happens. Now, can you send them on a wild goose chase? No. You have to know that it exists. You can't say, I want you to go do the work for me that I can't do myself or don't want to do myself, Mr. Prosecutor. So one, you have to know that it exists, and you have to know where to find it. And if you request it and the DA says, no, we can't get it, we can't find it, or we destroyed it, then you have to have a hearing, right? Normally, like I said, any good prosecutor, like I had a great boss when I was a prosecutor in a previous life, long time ago. He says, man, give the defense whatever they want, and we're still going to convict them, right? And even if it's bad for you, you don't want to convict an innocent person. So any good prosecutor say, I'll give you whatever you want. All right? I'm telling you, when the prosecutor says, I'll give you whatever you want, that means they've got a great case. When they start playing games, they start withholding evidence, they don't know where it is, they look incompetent. Look at the Linda Stanley case in the Morphew case, right? Started playing games, didn't know what it was. Ultimately, the case gets dismissed. She's potentially, has disciplinary actions because of some of her conduct in that particular case. And prosecutors should be held accountable when they don't turn over discovery. That's how people get wrongfully convicted. Because there's a note, there's a memorandum somewhere where they, say, hey, we're not going to present this evidence. Or somebody says, no, there should be another report in there that I wrote. Oh, we don't have it in our file. Oh, did we? Did we forget that file? Oh, we forgot that file. Sorry. And 20 years later, after somebody's been in prison for a long time, they finally get that particular note. And, could have made them innocent, actual innocence. So a good prosecutor is going to, give you whatever you want. Okay. But they can't do it endlessly. Like I said, you have to know what it is, that you have to be able to confirm that it exists, know who's in control of it. If they report to the district attorney, then if not, then you have to produce a subpoena to the person. But you can't you can't go around subpoenaing the FBI. Oh, we want this report. I want the FISA tapes. First of all, it's got to be relevant. Feds aren't going to give you anything, supremacy clause. Even if it's out of state, right? The attorneys only have subpoena power in that state. So it gets very complicated. You want records? Okay. Try subpoenaing something from a Facebook. Try subpoenaing something from Instagram. You can't get it. They'll say you must subpoena the person who you're requesting it from. But the police officers can request it under a federal law where they get everything they want from the people. They just preserve. Oh, we're going to hit the preserve button. And that's it. So, yeah, they can't continue it forever for sure. But it shouldn't be turned over. And if reasonable minds can't agree, then ultimately they go back to the court and say, Judge, we're requesting this specific information, as we've seen in the Brian Kohberger matter, where the prosecution has been ordered to turn over information that was in the care and custody of the FBI. Remember specifically the request for the genetic genealogy. Remember when Brian Kohberger got arrested, they got some food out of the house and they did a test on it. And they determined that he matched the person, there's a close enough match. They use that to get probable cause. Then they come back and they do a DNA sample. They go to court and say, Judge, we want this 41-1 because we need to get his DNA to have an exemplar to compare it to. So they get that and they say, aha, it matches the DNA that we found on the K-bar, and therefore they don't need it. So the prosecutor's like, I mean, we arrested him, right? Sure, we had some stuff, but we don't even need all that stuff the FBI did in their genealogical history, genetic DNA, genealogical DNA, as it relates to the development of that. So, one, we don't have it, the prosecutor said. Two, that's to the FBI. The FBI doesn't report to little old me. I'm just a little prosecutor here. And third, that's work product. We don't have to turn that over. And the judge said, no, they worked with you on it. It was reported to you. You relied upon it. And you can tell the FBI to produce it because they did, in fact, work hand in hand with you on this particular case. So turn it over. And it makes you wonder, well, why wouldn't they want to turn that over? Well, because, the FBI doesn't want to let you know how they do things. I mean, FBI, they just started recording video interviews of defendants. They would never do it. Just had the old 302 form. Yeah, the client came in and confessed. It was amazing. He said everything he could. Wow. He used to cross-examine the agents. Wow, you said my client confessed to everything, but we didn't record it, did you? No. Okay, well, did you have a little cassette recorder in the police department there in the entire FBI? Yeah, I'm sure we did, but I didn't have access to it. Well, did you have a phone? Well, yeah, but I didn't record it. Well, certainly you have a pen and paper there at the FBI office, do you not? Pen and paper. Well, we do. Well, then did you have my client write it out in his own words? Have him write it out what he did? Well, no, I didn't do that either. Oh, so you didn't record it in any way. You didn't have my client put it in his own words. We just have your word to rely upon it. Yep. And I'll be honest with you, I miss that. I miss the handwritten confessions that we used to get. Made life so damn easy. Seriously. Video's good, but now you got to watch a bazillion hours of it. Whereas before you're just like, I'm Joe Blow and I confess that I did these terrible things. I'm a horrible human person. I'm sorry. I ask for forgiveness. You ask the client, did you write this? Did you write this? Yeah, I did. Oh man. Yeah, I don't know what I was thinking. Well, it doesn't matter because it's done. You've confessed. So anyway, there you go. Brian Kohberger, his attorneys are going to request away. Now, let me tell you, I am very impressed with Ann Taylor. She's the lead counsel, former public defender in private practice. She does a lot of work, obviously. She's done several death penalty cases. And I'm telling you, every time she shows up in court, she is light speed ahead of the prosecutor. And I don't mean that in necessarily derogatory way. I'm just saying she's better. Okay? She is just better than the prosecutors are. Every time she gets up and speaks, it's clear, it's concise. She knows the point she's going to make. She shows up ready. There was that one motion in the hearing when they wanted to stop the sampling for the survey to see if there was too much bias or prejudice in Latah County as it related to Brian Kohberger for the motion to change venue. The prosecutor shows up. He got a little file. He's got his computer, right? Because nobody has paper files anymore. All DAs do is type on their little computers these days. They don't look at you. And they're there, right? They're just doing their thing. And she's like, no, Judge, I'm ready to go. I got my witness. I'm going to call the witness. You ready, Judge? Because I'm going to call the witness. I think at first the judge thought he was going to what's the word I'm looking for? Control the courtroom. But she, Ann Taylor, she owns that courtroom when she's in there and she is speaking. So my hat's off to Ann Taylor. She's just better. She's just a better lawyer than the prosecutors. And I don't know what the final result will be. Nobody does. And whether it's goes to trial, guilty, not guilty, death penalty, not death, or some sort of guilty plea along the lines to avoid the death penalty, she's kicking butt. All right. Even though you have a client that, is kind of despicable, if true, she has a client that, allegedly killed 4 people, 4 college students in their prime, getting ready to go out into life and cut short. We still have no real motive, right? And I know. You're going to say, Scott, is it time? That's right. For the K-bar, right? We still don't know where is the K-bar. Did he actually buy a K-bar? Okay. Because when you have a K-bar, ladies and gentlemen, you don't lose it. I got this in the summer of 88, for God's sakes. 88. Can you do the math on that real quick? God, that's a long time ago. My God. 88. But the point being is I still have it. 12 years, whether on active duty or reserve, 12 years, still had it and had the same one since 1988, right? I mean, those are going to be the big questions. Can they trace the K-bar back to Brian Kohberger? Can they do that? I mean, don't get me wrong. We've talked about it. We got that little DNA right there. And I'm telling you, this little sucker, when it was brand new, it was tough to get that thing there. You could understand how, your little DNA, your sweat, your little skin cells getting right there. Yeah, rubbing it in, trying to get that thing. It was tough. Okay. So when people say, oh, he just can't put his trace DNA on there. Yeah. But if you got to push hard enough to get it in there, see how you can get it there? Yep. Nice smooth surface, right? Any DNA expert will tell you smooth surface, more likely to transfer DNA, even fingerprints for that matter. Not like wood or rough objects, right? It's smooth. Now, so don't get me wrong. Obviously, every criminal defense attorney and Ann Taylor and her team have looked at it and said, all right, team, we've got a guy accused of killing 4 people. The state hates him. The county hates him. Everybody hates him. And we've got the best job in the world because we hate the most despised guy in town. And although he may be a big scumbag, he's my scumbag, and we're not going to let him get him. All right? And then they said, all right, what do we got? We got this video of the car that the police say it is. We think we can disprove that. All right. We got a knife problem, right? They say there was a knife, a K-bar, or maybe the sheath was thrown down in between the body or underneath the body of another, just to throw somebody off. Okay. Any alternate suspects? No. Okay. So what do they have to do then? They say, what is the worst piece of evidence that we have? Hint, hint, hint. That's right. The button, the DNA on the button. And as any good defense attorney is going to say, right? Just like if you have a client that is confessed, what's the worst piece of evidence? It is my, it's my client's statement. If that's the issue. So you think, oh my God, how do I make this client go? I need to make this go away. And I guarantee you that is what keeps up Ann Taylor and her friends at night, her coworkers at night, trying to be able to come up with a way to explain that. Right now, they're going to show flaws, right? They're going to go back to the genealogy. They're going to throw you off. They're going to be, oh, look at the knife over here. Look at the knife over here. They're going to, use a little deception, right? A little cover and concealment. And they're going to do what they can, right? Going to engage a little Sun Tzu art of war, zig, when everybody thinks you're going to zag. That's actually not, that's a summary of Sun Tzu, The Art of War. That's the Scott Reich version of it. Dude, do the opposite of what everybody thinks you're going to do. It's the best thing that blows their mind at trial. It's beautiful, beautiful, throws them off. So, but that's what they're thinking. How do we make this go away? They're going to say there was a flaw as it relates to the DNA that developed a profile that was flawed. He never should have been arrested. Oh, and then they got to come up with a DNA analysis, right? I mean, there's people, well, it could have been planted. Okay, what evidence do you have of that? What evidence do you have? Well, it could have been, okay, not admissible in court, speculation. What evidence do you have? Well, I don't have any. Okay. So we can't speculate, but we can say what we do know. They have a knife sheath. And regardless of whether you think how it got there, you still have to deal with reality, right? And the reality of it is you found a knife sheath that's underneath a body. No knife, granted that. And his supposed DNA on it. I mean, those are facts you cannot ignore, ladies and gentlemen. I know there's a lot of people out there. You just never know. Okay, what uncivil law? Well, since we don't know what knife did the stabbing, how about it's just a random piece of trash unconnected to the crime? Could you try selling that? Okay. But once again, ladies and gentlemen, I mean, hey, you can try to sell anything you want. Hell, I have even done that, ladies and gentlemen. I have done that. I have done some horrific cases, ladies and gentlemen. Horrific. Okay. And sometimes you get into what you refer to as trial psychosis. Okay. You're saying, what is trial psychosis? Well, you got trial psychosis, and then you got yourself checking into the penthouse suite of the trial psychosis hotel. And you're literally like, all right, this case shouldn't have gone to trial. My client has turned down every reasonable offer. I have urged him to take every reasonable offer in this case. Frankly, the offers are probably even better than I think they should have been. But the client wants to go to trial. He wants to exercise all of his constitutional rights. Let's go do this thing. So you start thinking to yourself, all right, I'm getting into trial mode, trial psychosis mode. Here it comes. Okay. You start thinking to myself, other than all those witnesses that saw everything, other than the video, other than the confession, is that all you got? Other than the jailhouse calls from your client explaining how he wants people not to show up for court, consciousness of guilt, tampering with witnesses, witness intimidation, you think to yourself, oh, I can do this. I can win this. Is that all they got? Let's go to trial. And you get up there, ladies and gentlemen, my client is not guilty. All it takes is a mere allegation to get through those doors. And when you hear the evidence, the prosecution is not going to be able to sustain their burden of proof beyond a reasonable doubt. And when you hear the evidence at the close of this case, you've seen it all and you apply the law to the facts, you'll have an easy, simple decision to make, and that is not guilty, right? Anybody can get up there and make that simple opening statement. Not guilty, burden on them. They can't prove it. Just watch them. They can't do it. I'm telling you, I've had cases where literally it was on video of people shooting people, right? My client's like, that ain't me. I'm like, that's not you. I think I've maybe talked about this once or twice. Horrible case. Client allegedly goes, robs everybody, at 7-Eleven. Everybody in line. Give me your money. Give me your money. 10 to 32, 10 to 32, 10 to 32, 10 to 32. Separate victims, 10 to all crimes of violence. Promptly proceeds down the road, goes into another store, asks for a bag of chips, then tries to rob somebody, shoots the guy in the belly, going through his spine, paralyzing him. We had to go with the "that ain't my baby" defense. All the client would ever say is, "That ain't me." And I would look at the photograph, and it was a long time ago. Don't get me wrong. I mean, it was grainy. It was grainy. And you try to enhance the picture. None of this 4K high definition stuff you get today from everybody, right? It was a little grainy. I was like, man, that ain't me. That ain't me. I'm like, okay, well, I'm your attorney, and I think it looks like you, but who am I to know? So I take a picture to my client's mother, and I said, ma'am, I have one question to ask you. Is this your baby? She looked at me as though the sky had opened up, and she said, Mr. Reich, as God is my witness, that ain't my baby. Okay, we got a defense. Let's go do it. Everybody comes to court. That's the bad man that robbed me. That's the bad man that robbed me. That's that bad man that robbed me. Then the guy that comes in paraplegic in his wheelchair. And he literally, like with his moves with his little finger or something, moves his chair around looking for, do you see the man in this courtroom that shot you? And he starts looking at the jury. And I'm thinking, he's going to pick somebody in the jury. This is fabulous. And then he does his little finger with the chair thing. And he looks over at the prosecutor's table and looks at a guy at the prosecutor's table. I'm thinking, oh my God, he's going to pick the investigator sitting at the prosecutor's table. This is amazing. And then he moves again. Moves a little chair over. And with this one little good finger that he can move, that he moves all his chair around, he goes, that's the man that shot me, pointing at my client. Whereupon the client stands up and said, I didn't effing shoot you. And of course, it's all in front of the jury. We have to calm everybody down. And, Judge, it's a mistrial. Oh my gosh. But then once again, you're thinking, is that all you got? A guy suffering the trauma of being shot, no good look, no previous identification, coming here today. Of course, he picks my client because he's got the little placard on the table that says defendant. What else did you expect him to do, ladies and gentlemen? It wasn't a valid show up or line up in any way whatsoever. And you can say, but wait, there's more, right? I've got his mom. And who doesn't know their child like anybody in the world but their mom? And so you put the client's mom on the stand. Ma'am, how are you today? Good. Is your son here? Yeah, that's my baby. That's my baby. Sitting over there. Do you have other babies? Oh, I got lots of other babies. Yep. But he's my favorite baby. He's the oldest. He took care of everybody. When we couldn't afford anything, he took care of it. Always found a way. Not sure how he found a way. Could have been by robbing people. I don't know. Anyway, so then we fight to the big question. Ma'am, I want to show you a photograph taken from the video of the night that this man, your son is being accused of shooting him, paralyzing him, causing serious bodily injury, and attempted murder. Ma'am, I want to know, will you take a close look at this photograph? Why, yes, I will. Studies it. Ma'am, I just have one question for you from the jury, and to tell the jury this, please. Is that your baby? No, she responds. That is not my baby. Hey, if you can't trust a guy's mom, who can you trust? Right? And of course you ask her, ma'am, if that was a picture of your baby, would you say it was your baby? I raised my baby to be a responsible young man. If he had done it, I would have dragged him in here by his ear and told him to plead guilty, but that ain't my baby. I believe my baby. So we go through emotions, we rest our case, closing arguments. You can't believe them, ladies and gentlemen. Travesty of a mockery of a sham. That's what this is. If we allow this man to be convicted on such weak evidence, where's the DNA? And one of the best lines I ever heard from a prosecutor who's now a judge, and when we get together, we still joke about it. I said, where's the DNA? Where's the DNA? Because my guy robbed somebody, they touched something. They didn't even check for DNA. In fact, they put that was robbed, that was dropped, they put it back into the cooler and didn't collect it as evidence. We can't trust this. And where's the DNA? That would be to prove anything. And the DA gets back up on his second closing and it's like, yeah, DNA stands for one thing. Don't need any. And I literally probably smiled when he said that. I mean, like I said, he was a prosecutor, he was a U.S. attorney, now he's a judge. We still chuckle about that line. Everybody remembers that line. It was like touche, because we were going at it hard. And needless to say, what can I say? The jury thought that that was her baby that robbed everybody. And I think he got like 164 years or something along those lines. See, I can laugh about it now. It's only taken me, 18 years. But it just, you get in, like, okay, we're going to trial. Let's go do this thing. Trial psychosis. You can't let that get in the way of the facts. But if your client wants to go to trial, you got to go to trial. Attorneys, real trial attorneys, are going to go to trial and do cases that they don't want to do, that they don't want to be there. Okay. I mean, I represented a guy once, former priest of some type. He used to take in foster kids of a very specific age and racial demographic. And then all these people were coming to court saying that this former priest would do terrible things to them as young boys. And none of these people, they had these same stories, and they'd never met. Coincidence? I think not. So, you got to go do trials, right? I think I told you probably one of the worst cases I've ever done. I know I've mentioned this before, but since we're in worst story mode here, this is why when I tell young ladies, and this is my biggest, I think you're wrong about homicide. Let me see, Brenda. She disowned him, I'm sure. That would make it great. Okay, I have to go back and look at some of that. Anyway, worst case I ever done. This is why it was always my worst fear, having a young daughter. Horrific case, and I will never ever forget it. I'll never forget the sound of this young lady's voice on the 911 call. And this is why I tell everybody, be aware of your surroundings. If you think somebody's following you, make noise, run like hell, fight like hell. Literally, this guy gets out of prison on, we'll just say, day one. Day one, release from prison. Guy goes to his parole office, gets sideways with his parole officer. Parole officer says, why don't you go home and we will try this again in the morning. We'll see you in the morning. So guy's a little upset, not happy, doesn't want to have to come back tomorrow. He gets on the bus. He's going home. He's going through an area where there's lots of apartment buildings. Young people live there, near a college and things like that. Young, working type people, apartments that are nice, but not so nice. Anyway, this guy sees a girl, a young woman, getting out of her car with her hands are full. And she's actually carrying like a carrier for like, you know, from McDonald's. She has a big McDonald's bag and, you know, another bag, and carrying a couple of drinks. And she goes to an apartment, but this guy sees it, you know, the bus, like, you know, they pulled a little rope, ding, ding. He gets off the bus, follows her into her hallway in the apartment, like follows her there, realizes maybe something's not right, but she tries to get into the apartment quick enough. He then pushes his way in. Pushes his way in, tries to do certain things, but unfortunately he could not get things to work at that time. So then he forces her to do other things. He finishes. There's stuff remaining on a shirt, things of that nature. Tells her, if you tell anyone I know where you live, I will come and kill you. So imagine this woman now in an apartment, her place, right? Her castle, where somebody has pushed their way in, done terrible things to her. She's at this point basically naked in a corner. She calls a friend, and she calls a friend and says, I've just been raped. Please come help me. The friend comes home immediately, finds her there in the corner, literally like the fetal position, crying, just cannot believe what's taking place. They call 911. The young lady, she's like, no, don't. He said he'd kill me. He knows where I live. The most horrific scream, just terror in her voice. You can hear it. Needless to say, they call the police. Guy gets arrested, screws around for a while, you know, with the courts, you know, he gets a public defender, this and that, with everything else. Make a long story short, who do they call? The client whisperer. Judge was like, I need you to take this case. I know you can get the case done. Go try the case. We got to move along. Okay, sir. Right? Horrific case. And I remember thinking to myself, I don't even know what I'm going to say in opening statements. Don't even know what I'm going to say in opening statements. It was that bad. We got the jury, right? And remember when I said she had her hands full? Right? Remember, I don't even say it's trial psychosis. Maybe it was just, you know, I don't know. Ladies and gentlemen, they call the first witness. I was like, not guilty. You know, anything that took place was completely consensual. And, you know, the prosecutor's like, what? You only got a couple of defenses, right? It didn't happen, or it was consensual. You know, it was consensual, right? You can argue the reasonable inference is drawn from the evidence or the lack thereof. Well, isn't it true, Ms. Victim? You had 2 meals in that bag. I see them here in the photographs in your house. And I see 2 large drinks in this little petite little girl. In fact, because there were 2 people coming over. Isn't that so? Anyway, wasn't going well because they'd actually played the 911 tape of her. And, you know, I had jurors crying when they played that 911 tape. Crying. Like, that's not good. So sometimes you have to go do cases you don't want to do, but you got to be able to explain away stuff. And if you can't explain it away, like we bring this back to Brian Kohberger, it's not going to go well. So unless they can come up with an explanation why Brian Kohberger's little stuff is here on the DNA right there, it's not going to happen. Yeah, you could always not give an opening, but I don't like that. I don't like that. I like to give an opening. You need to come out bold. You need to come out strong. Let them know, hey, when this guy gets up, I want to listen to what he has to say because he seems like somebody who knows what the heck he's doing. I don't think I've ever waived an opening unless it was a trial to the court. Have I ever waived an opening? It's your opportunity to tell your side of the story, theory, theme, over and over again. Client not guilty, client not guilty, client not guilty. Uncivil law. Did I win? No. I know. There's some attorneys out there like, I've never lost a case. Well, then you've never tried that many cases, particularly in the criminal defense world. You're not supposed to win as a defense attorney. But when you do, God, it's sweet. God, it's sweet. So anyway, now the other thing, just so we're here on the whole knife thing, Brian Kohberger, like I said, this is a terrible knife. All right. A K-bar is a terrible, terrible knife. Maybe for digging a hole to maybe start a little fire, maybe a little hole to, go do your business out in the woods kind of thing. This would be a good knife. I've had terrible luck with this thing. This thing can't get sharp. It's terrible. It sucks. It's heavy. And also, when you start stabbing people, this is the one thing that I think is in Kohberger's favor. He does not have any injuries that we are aware of. Okay. You start stabbing somebody, assuming it's this type of knife, which I'm sure we'll find out at trial. If this was the exact same knife, a K-bar. But when you start stabbing something and hitting it hard, guess what? Your hand's going to slip. You can get bruising, you can get cutting. Hell, your hand can slip where, you hit some bone or something and it's going to slide on here and you're going to hurt yourself. I mean, stabbing like that, it's usually with a slash, that kind of thing. So just something to think about, ladies and gentlemen. But I guess the moral of the story is you got to be able to explain it away. Okay. And regardless of the trial psychosis that you get into, you have to be able to explain away the bad facts. If you can't explain away the bad facts, you got to be honest with your client and you got to be able to face them. You got to be able to embrace, right? When you put your board together and you say, here's my good facts, here's my bad facts. How do I move my bad facts over here to the good side? And if you can't move your bad facts, like embrace the bad facts and move them to the good side, the good column, well, you got a problem. And you think the prosecutor hasn't thought about those things as well? And I guess that's one of the most frustrating things that I see oftentimes when I watch other videos and people's commentary is they just ignore the bad facts. Well, I've chosen sides and I believe that, this is going to be great. I'm going to ignore all the bad facts. And, when the side that I have chosen is lost, I will say they didn't address the bad facts. Right? You have to address the bad facts. We're talking about a court of law. We're talking about people's lives. And you have to be intellectually honest. It's not like you're saying, I'm a Denver Bronco fan, and regardless of what the Broncos do, I will, be with them forever and ever. And no matter how bad the defense looks, I can say, well, we're young, it's rebuilding year, it's going to be great down the road. But the fact of the matter right now is presently, like the defense sucked, right? You can't ignore that. You have to be intellectually honest. And like I said, I think I see a lot of people out, they just ignore facts. We had a lady call up last week. She was nice enough. Do you remember her, Frank? The lady that called up that, it could have been this and it could have been that. And what I said, what evidence do you have? Well, none. Okay, then that's speculation. It's not coming in. It's not coming in. So what do? You can't ignore the bad facts, ladies and gentlemen. Bad fact for Brian Kohberger. He's got DNA. I'm sure there are lots of other bad facts. No good alibi. No great alibi. I assure you, if I had a valid alibi that I was not at a murder scene on the date in question, I certainly by now, a year and a half later, would have told my attorneys, you need to do this, check it out. It's going to exonerate me, and go from there, right? Specifically, like I said, on November 13th of 2022, by now I would have racked my brain, looked at my computer, checked my calendar, had a good explanation of where I was. Not, oh, I just happened to turn my phone off or I had lost reception. I was out driving around looking at the stars. Oh, okay. So you were somewhere between the murder scene and your apartment and maybe some other direction. You can't possibly tell me. Okay. I mean, if there was a valid alibi, I don't think their notice of alibi necessarily in the Kohberger case is a great one. Well, he was somewhere between here and there, driving around. You know how it is. And really, apparently, the only one that can really testify to that is going to be a cell phone expert, I guess. Maybe you get an alibi. But like I said, in almost 30 years, in December will be 30 years as an attorney. Never had an alibi work in court, because if the client had an alibi, it wouldn't get to court because he wasn't there, right? The key element is that they have to show that, like, let's take a look at the original complaint here. Count 1, burglary. Now let's go to murder. That the defendant, Brian Kohberger, right? The prosecution has to prove that it was Brian Kohberger, not someone who looked like him, not someone using his identity, not somebody driving around in his car, holding on to his phone that night, but that it was in fact him. And on November 13th, 2022, in Latah County, state of Idaho, did willfully, right, knew what he was doing, aware of his conduct, unlawfully, which means without legal permission or justification, right? The only defense to murder is it was self-defense, deliberately, with premeditation, and with malice aforethought, after deliberation, fancy word for all that, kill and murder. We got Madison Mogan, Kaylee Gonsalves, Zaina Kernodal, and Ethan Chapin. Got an alibi. I say, wasn't me. Not my DNA. A year and a half's gone by. Don't you think if you had a good alibi, you would have seen that? So, yeah. Mary wants to know, were the stars out? Electric sunshine. Scott, you make me laugh so much. Well, I hope that in a good way, not because you think I'm an idiot. All right. Well, guess what we got to go do, ladies and gentlemen? We've actually gone over. We do this all quite a bit. We got to go do our Patreon show. And I'm going to be there very quickly. There's no trial to interrupt us. Last week, we had to break away quite quickly. We didn't really do a great Patreon show. I apologize to everybody. Now we're going to go do it. And we're even going to do the Magic 8 Ball. All right. So we'll be taking solicitation for questions for the Magic 8 Ball tonight. There it is. You can see the Magic 8 Ball. We got the old one. We got the new one. Next to all the CrimeTalk merch that we haven't really sold in years. But hey, if you want to go check it out, you can. It's still there. You can still buy some. All right. I want to thank everybody for watching. Thanks for joining us. We know there's lots of things you'll be doing. We appreciate you taking the time to spend it with us. Hope you enjoyed the conversation. And yes, remember, the Constitution matters. It's the playbook, ladies and gentlemen. It's the playbook. You got to follow it, even if you don't like it. And if you don't like it, guess what? There's a remedy to change it. There's a process. You just can't say we're going to ignore it. You can't do that. It matters. Thanks for watching. We'll see you next time. We'll see all our Patreon members there in 5 minutes.